और शुरू करेगा।
Good afternoon, everyone. A very warm welcome to all the participants joining us today for this insightful webinar on registered NPO trust compliance under New Income Tax Act 2025. I am Satyam Gupta, your session moderator for the today's webinar. On behalf of the organizer, CA Dr. Raj Chawla, sir, it is my privilege to welcome you to today's webinar. We are delighted to have such an enthusiastic and diverse group of professionals with us, and we sincerely thank you for taking out your valuable time to be a part of this session. I would request CA Dr. Raj Chawla, sir, give the welcome address of today's speaker.
Thank you, Satyam. Good afternoon, everyone. First of all, I welcome all of you in this today webinar on registered NPO trust compliances under New Income Tax Act 2025. And today, our guest speaker, CA Advocate Anil Chachra will discuss the following topics, that is the registration procedure under New Income Tax Act, the type of income, regular income and specified income, corpus donation, application of income, accumulated income, tax on accredited income, commercial activity by trust, specified violation and other violation treatment. So I welcome all of you and our guest faculty for today webinar. Thank you.
हाँ जी सर मैं दोबारा भेज देता हूँ सर Thank you, sir. We are privileged to have with us an enthusiastic expert, Advocate C. Anil Chachra, sir, who bring over 19 years of distinguished experience in tax consulting and litigation. His deep expertise spans merger and acquisition tax, international taxation, transfer pricing, and corporate tax, and he has represented client before appellate authority and high courts. He is a seasoned professional and a speaker at various professional forums. With these words, I would request our esteemed speaker, Advocate C. Anil Chachra, sir, to take the session forward.
First of all, thank you to Raj Chawla ji and his team to providing me an opportunity for this today's webinar at New Year Eve. So thank you very much, Raj Chawla ji, for this opportunity, for your kind support. I welcome you all. Good evening and a very happy New Year to all the participants. Uh, so as you know, the new income tax act has been enacted and is going to be implemented from this year, April 2026. So it's very eager us to know the various provisions in terms of the comparison of this Income Tax Act 1961 with the Income Tax Act 2025. So in 1.5 hour session, so firstly, I will take you through the overview of this new Income Tax Act 2025. Then we will discuss about the clause-wise clause analysis of this non-profit charitable institutions. So each and every topic of this tax will take time to understand all the implications. So during this time, given time, I will try to highlight the changes which has been brought out in the new act. So let me share my presentation. So I hope my presentation is visible to all. So
Yes,
kindly, yeah, yeah, and also confirm whether my voice is also audible to all of you.
yes, sir, audible, sir.
Okay, okay. So in the new year 2026, I think the lots of seminars is going to happen on this new Income Tax Act 2025, and the budget is also going to be come out on 1st February 2026. So this year budget will be based on the new Income Tax Act 2025. So before the budget came out, so we need to understand all the provisions of this act. But the today's topic is relating the registered non-profit organizations. So let me take you through the overview of this Income Tax Act, how it is different from the erstwhile Act 16.1. Uh, the finance minister in the budget speech in 2024. Yes, sir. Yes, sir. Hello.
हाँ जी सर.
Voice is clear?
Yes sir, audible sir.
Okay. Okay. So the finance minister, Mrs. Nirmala Sitharaman, has made announcement in last year budget that there will be a comprehensive review of this income tax act, because the language and the provisions are so much complicated of this erstwhile act. It's very difficult to understand for a common man in a very layman language. So the purpose of this overhauling and the comprehensive review of this new act was to make the act concise, lucid, easy to read and understand the act. Uh, so now the question is, as the new act has been brought out, so whether there is any policy change. Policy change means that whatever the main provisions which was there in the erstwhile act, whether there is any changes has been made out in the new act. The answer is no. There is no policy major changes in the new act. Whatever the interpretations and the words which has been pronounced by the judicial pronouncements and the various courts, the same has been retained with minimum modifications. So as far as this the policy changes, there is a no policy change in terms of the new act. Uh, so in terms of the language, we can say that the question is whether there is any a benefit is available for us to understand the act in an easy way. The answer is yes. Why? Because in the new act, see the table which has been brought in your screen. The earlier there is a 47 chapters. Now it has been reduced to 23. So in sections in the 61 Act, there's 819 sections, although the effective sections are 298 numbered sections. But there's a subsection, further subsections, which can be lead to the sections of 819, like in case of section 115A, 115B, 115C, it goes to 115WM. So there are altogether 115 sections. So now the effective sections has been drastically reduced by 819 to 53 sections. Words has been drastically reduced. The major change which has been brought out in the new Income Tax Act is the provisos and the explanation has been carved out, and it is part of the main section. So this is the major basic changes which has been brought out in the new act. So there is a no proviso and there is a no explanations, because there's a lots of litigation has been happened in case of the explanation part, whether this explanation is retrospective or prospective. So the same has been gone away, and now it has been part of the main section itself. So this is the drastic changes. So now, as the finance minister's speech, the purpose of this new act was to make the in a language, lucid language, or we can say that the easier language way. So what are the simplifications which has been brought out in the new act? Suppose if I want to understand the new act, if I want to read the new act in a thoroughly way, what would be the procedure that I need to follow to understand the language and want to comparison between 61 and 2025 Act. So there is a redundant provision has been gone away, like 10A, 10B, 10C. So the words and the sections has been reduced almost length by half. So that is a major change. So now in the main section itself, the tables has been brought into picture. Earlier it was given in the section and the provisor and the explanation part. Now, like in case of the registered non-profit organizations, the registration part, the accredited tax, the approval part has been given into the table form, just to understand the facts in a much broader and clarified way. So that is a major change. Now, third thing is that subsection and clauses have been used instead of relying on the provisos that I've already discussed about that provisos, and the explanation has gone away. Now it's part of the subsection and clauses. Minimization of cross references and conflicting by aggregating of all applicable provisions related to single scenario in one place, like in case of registered non-profit organizations, the charitable trust. All related sections have been part of in one chapter instead of spreading in the various other parts of the sections. So this is a major change. TDS sections. So all sections have been brought into the table format. So that is a major change that has been brought out. So now what they have done is they have given the formulas and tables just to enhance the clarity wherever feasible. So this is like in case of suppose a capital gain chapter or charitable trust chapter. If suppose accredited tax, we have to calculate how we will calculate it. They have given the formula itself in the main section itself within the table. So that is the easy way to understand the tax in a much better way. Um, so definitions relating to a particular chapter, like in case of the capital gain, whatever the definition that have been given, have been used, have been given in the same section, same chapter itself, in terms of the interpretation part of that chapter. Like in case of the registered non-profit organizations, the all definitions has been given in last part of the chapter called the interpretation. So all definition has been given into the same chapter. So each chapter now easy to understand, and cross references has been done in the same chapter itself. So one major change is that the assessment year and previous year has gone away. The same has been replaced with the tax year. So tax year has been replaced. So now earlier there was a confusion. What is the previous year? What is the assessment year? But now the same has been replaced. So overriding provisions. So overriding provision means that one provisions override the another. Now the language has been changed in a manner that earlier the language was notwithstanding anything to the content, a contrary content. The same has been replaced with irrespective anything to the contrary. So now in terms of the legal language or the judicial part, whether it has an implication because it has not been tested so far, but up to my knowledge, this type of language, notwithstanding anything, with the irrespective anything to the contrary, doesn't make any much difference as far as this legal interpretation is concerned. So that is the major changes that has been brought out in this new act. So this 2025 act has been based on the Finance Act 2025. Whatever the uh, whatever the changes that has been brought out in Finance Act 2025 till 2025 Finance Act, the same has been incorporated into the new Income Tax Act 2025. So first base to read the Income Tax Act 2025 is to take the first book of Income Tax 2025, 1961, with the updated budget of 2025, and then try to read with the Income Tax Act 2025. So that would be the first step to understand the concept of this Income Tax Act 2025 in a much better way. So, these changes are the general in nature. So any specific changes has been brought out? Yes. So specific changes has been brought out, like in case of the section 10, which was the exemption section. So in section 10, there was 150 clauses was there, or we can say that 150 subsections was there. The same has been given into the tabular form. So in the schedule form and in the tabular form. Schedule 2 to Schedule 7 cover all the exemption sections. They have categorized into the resident, non-resident, capital market, or in a journal exemption. So they have given the exemption in the schedule itself and in the tabular itself, with categorization of whether it will be applicable for the resident, or whether it will be applicable for the non-resident, or whether it will be applicable for the International Financial Service Center, IFSC, or capital market, and so on and so on. So this is the major change that has been brought into picture, because earlier it was very difficult to read section 10 itself. Now, the major change in the non-profit organization, which we will discuss in in today's part as well. So these non-profit organizations chapter, which we call the charitable institutions, were spread into the various sections like section 10, 23C, then 11, 12, 12A, 13, then specified income sections like 115 BBC, BBI, then accurate tax. There was a separate section of 115 TD, TE, TF, and then there was the donations given to the charitable trust and under ATG. So all have been simplified into one chapter under the chapter of chapter 17 called special provisions for registered non-profit organizations. So that is a major change because now if you want to read this non-profit organization or section 10, it's easy to understand because all section has been tabulated into the particular chapter itself. Now it's not any difficulty to understand because all section have been incorporated into the particular chapter. The another changes has been made out in the salaried cases. So earlier, the section 16 and 17 was there for the salaried sections, and section 10 was used there for the exemption part. Now all the same thing has been brought into picture of the main section itself, section 16 and 17 in the new act itself. So there is a no reference to section 10 itself. So that is a major change. TDS, yes, TDS, there is a lots of changes that has been brought out into the picture. All provisions has been given into the tabular form and with the headwise like commission and salary, rent, capital market. Now, there was earlier section called section 195, which was applicable to the non-resident. So they have given into the tabular form, item number 17 of this that table. So when you compare your 61 Act with the new Act, you will find a lot of changes, but main thing is that there is a no policy or there is a no policy change, but the contents are same, but the aggregation and segregation they have brought into the new act. So that's why there will be a lot of difference you will find when you compare the 61 act with the 2025 act. So this is just a tabular form. This income tax act will be applicable from 1st April 2026. So that means the coming month, 1st April 2026, and it will be applicable called as a tax year because there is no previous year and assessment year. So the term will be called tax year 26, 27 as per the new act. Suppose I will earn a salary, right, from April onwards, or I will earn a commission. So whatever the TDS, whatever the capital gain, whatever the business income I will accrue from 1st April onwards, that will be accounted for under the new act only. So now this previous act, erstwhile act, 61 act, is applicable till 31st March 2026. So previous year 25, 26, and the assessment year would be 26, 27. So till 31st March 2026, the assessment year will be governed as per the previous act, means as per the 1961 act. So there are the two things. First thing is that whatever you will earn till 31st March 2026, so it will be assessed under assessment year 26, 27, and it will be assessed under as per the previous act, means the erstwhile act 61. Whatever the earning you will get from April 2026, it will be covered under the tax year 26, 27, and it will be assessed as per the new act 2025. Right. So these are the basic things that we keep in mind whenever or which chapter you want to read, because these are the basic thing that we need to keep in mind to understand the facts in a much more broader way. So any questions so far in terms of the applicability and in terms of the comparison between 61 and the 2025 act? So is there any questions? Okay. So now there is a as and when the new act comes into picture, right? Any act comes into picture, there is a term called repeal and saving clause, because unless and until there is a repeal and saving, the act can't come into picture because the operations can't come into picture. What is a repeal and saving? Repeal and saving means that till 30 till 31st March 2026, you will be assessed as per the previous act. Suppose you are a company, right? Assessment will go on, reassessment is going on now from 1st April 2026. The new act comes into picture. So what would happen about the previous exemptions, previous returns, previous pendencies, previous refunds? If you are claiming Section 80 sections, if you have registered under the old, as per the charitable trust under Section 12AB, 12AA, what would happen in the case of the new act? So that's why this is called the repeal and saving section, and it's very important to understand the, or just to read the new act. This is a very special clause which we need to keep in mind to understand the facts. Like what would happen in my previous assessment, what would happen my previous refunds, what would happen my previous notices which will happen, like 147, 148 notices which have been, what would happen the court cases which is pending as on 31st March 2026. And if the results come after 4 years, whether it will be assessed, it will become under the new act or it will come under the previous act. So each and everything has been defined in section 536, which is called the repeal and saving clause. When this 1961 act came out to picture, so same clause was there. What was happening in the previous operations, the same will continue in the new operation as well. So each and everything has mentioned, like case of the, if proceedings are pending or initiated after 1st April 2026 but is relating to the before 31st March 2026, so it will be assessed as per the repealed act. So this act will become the repealed act. 61 act will become the repealed act. So income tax act 2025 will be the new act as per this section, as per section 136 536 of this income tax act 2025 is concerned. So each and everything, so I'm not going to discuss each and everything of this repeal and saving, but it is important. One thing is important is that, like in case of proceedings, any cases which are pending as on date, and it will be settled out 4 years, 5 years, or 6 years down the line, it will be disposed of as per the repealed act if it's pertaining to 31st March 2026, before 31st March 2026. So any declaration options which has been given, like a 10A scheme or eight or under 80 deduction scheme, if you have claim any given the options with the income tax authority, shame will be deemed to be continue under the new act as well. If any refund is payable, which is pertaining to before 31st March 2026, how the interest will come into picture, whether the same will be given as per the new act or whether the same will be given as per the old act. So interest will be given as per the new act. So if any support deduction allowed and you have violated the conditions of the deductions, like 4 years prior to that you have allowed the deduction, but now you have violated the conditions which has been prescribed under the income tax act, so it will be treated as a deem, it will be treated as an income under the new income tax act. So each and everything they have given, any circular or notification or agreement will continue to govern as per the new act. Like in case of the DTA section 90, if the government of India has entered an agreement with more than 200 countries, this double taxation avoidance agreement, now then this income tax act comes into picture, 2025 act comes into picture, the same will continue to be governed if it's not inconsistent with the new act, right? So another major change, another major clause that they have discussed in the saving clause, that no extension, or if suppose the time period has expired under the old act, so the same will not be treated as the extension as per the new act, right? So because this is the this will happen in case of 147, 148 notices, because there will be a plethora of litigations would come into picture. Suppose in case the time period has expired and now the suppose the time period has changed 4 to 6 years, earlier it was 5 or 10 years. So this thing will trigger out in that case. So MAT credit to be allowed to be carried forward under the new act. If you are having a set of losses under the repealed act, the same will continue to be governed as per the new act, right? If you have calculated the losses and maximum 8-year period was expired, is available for set off, the same will continue to be governed as per the first computed. If 5 year has lapsed in the new act and 8 years is the maximum time period, the 3 year will be available under the new act to set off your losses. So all policy changes will remain same. In case of the amalgamation, section 72 way, depreciation and losses of these of amalgamated company, the same will continue to come into picture as was available under the 61 act. So same thing is will be governed under the new act as well. So there's no changes. uh, if the withdrawal of conditions, I have already discussed it, so will be chargeable new act. If capital gain you have got the exemption if a wholly owned subsidiary transferred to the parent company or parent company to wholly owned subsidiary, it is exempt under section 47. But if you violate the conditions, now it become taxable under section 47A. So if 5 year prior to that you have availed the exemption, now you are violating the condition, the same will be taxable. So each and everything they have given what type of the exemption was available. Now you can continue that exemption under the new act as well. Uh, so depreciation, carry forward the depreciation. Section 32, subsection 2, which says that the unabsorbed depreciation will be treated as current year depreciation. The same will continue if unabsorbed depreciation is there, and the new act, it will be treated as a current year depreciation, and the same provision will continue to apply after 31st March 2026. So amortization of expenditure under 35 ABA, ABB, D, TD, TDA, 35E, where 5 year or 10 year amortization is allowed. If any remaining amortization is pending, the same will be allowed in the new act as well. So there's a one provision for doubtful debts will be added to the, if suppose 31st March 2020, the 31st March 2026, any provisions of doubtful debts which are lying in your books as per the Income Tax Act, and same will be added to the provision under the new Income Tax Act for treating the provisions under the new act. So there is a lot of controversy in terms of JAO versus FAO, like in case of the 147, 148 notices, wherein it is held that who will issue the notices, whether the jurisdiction assessing officer or faceless assessing officers, because this repeal and saving clause says that whatever the notification which has been issued under the old act will continue to apply. So same controversy will govern under the new act as well, because lots of litigation has been going on in this JAW and FAO category. So another thing is that search initiated uh, under the repealed act. So provision of the repealed act continue to apply if search will happen uh, before 31st March 2026. So provisions of the old act will continue to apply. So each and every fact they have brought out. So this is a controversy, as per my opinion. This is the last thing. In case of reassessment conducted under the new act for prior years, then reference will be for the previous year, because in the new act there is no assessment year in previous year. So as and when the reassessment is conducted as per this Income Tax Act 61 is concerned, the same will be governed by the assessment year, 3 years or 10 years, right? Depending upon assets found, it's 10 years, otherwise 3 years. Now it has been reduced to 5 years. So the earlier the regime was assessment year and previous year. Now suppose after 31st March 2026, right? Suppose in April or May 2026, you have the department has issued a notice of 147, which is pertaining to 4 years or 3 years, suppose 23 assessment from 23, 24, 24, 25, 26, 27. So in that case, the saving clause says that the when as and when the prior to the 31st March 2026 is concerned, it will be treated as previous, right? Because now it's a tax year, but prior to 31st March 2026, it will be treated as previous year. So how the calculation would be made? Because the earlier the calculation was be made from the assessment year itself. So how the calculation would be made? So I think that will create a lot of litigation because there's no clarity about this clause because there's no assessment year and previous year. The same has been replaced with the tax year. So how the reconciliation would be made between the tax year and the assessment year when you receive a notice after 1st April 2026 under the new act, which will be relating to 3 year or 4 year prior to your assessment year. So how would you calculate it? So that thing, I think, to my mind, would create a litigation because that seems clarity, lack of clarity in terms of this clause. So this is a repeal and saving clause. I think as and when you will read this Income Tax Act 2025, uh, uh, so it would be very crucial to understand the facts of repeal and saving. Unless until you read the repeal and saving, it would not be easy to understand the new act. And if you suppose you're working in industry or practicing as a CE or so how would you treat your exemptions or the exemptions, claims, or losses? How would you treat under the new act? The same will be treated through the repeal and saving clause. So that is relating to the which we can say that overview of this income tax act. Whichever topic you will try to understand or read, this will cover you the holistic picture of this act to inculcate your experience of the 61 act into the 2025 act. So this was the overview. Now let's the tax year. So the same has been replaced. The previous year this has been replaced with the tax year. The definition has been given. The tax year means period of 12 months, a financial year commencing from 1st April. So there is a no basic change, just only the terminology has changed. Previous year has been replaced with the tax year. Now come on the technicalities part of this registered non-profit organization. So far, is there any questions from the audience side? So any questions?
Yeah. So can I?
Yes.
So whether this DTA would continue to be the overriding in case of new act also?
So DTA would continue because in the say repeal and saving clause it says that all notifications, all circulars, all agreements which has been there in the erstwhile act will continue to apply unless until there's any inconsistency between the old act and the new act, right? So there is no inconsistency between the old act and the new act, so it will continue to apply.
It
But
will continue to be as overriding.
no, not overriding. It will no. Overriding would be there. Section 92 in
Correct.
the says that the Ajadi Bachao Andolan we says that the uh, the the DTA provisions will prevail over the Income Tax Act. So same will continue. Right?
Okay.
Same will
Thank you.
continue. Right? Same will continue. But yes, in terms of Section 9, in terms of the royalty part, so there is a controversy regarding when these engineering analysis judgment which was there. So when you read this engineering analysis with the new act and with the DTA, there's a lot of controversy will come into picture when this new act will be implemented from 1st April 2026. But yes, DTA will override the income tax act, right? So now, any other further questions? Okay. So non-profit organizations, registered non-profit organizations. So this is governed by Chapter 17, Chapter 7, Chapter 17. Uh, this is governed by Chapter 17, right? With Section 332 to 335, right? Yes. So let's first understand the definition part, charitable purpose. Now the same has been replaced with registered non-profit organizations. So I have made this presentation in a tabular format. The left side, which is seeing in your screen, which is shown in your screen, it's 61 Act. Right side is 2025 Act. Blue part is there, which has been changes. And there is a one column of changes in the right side, right? So this is the theme of the presentation when we will are doing this the charitable trust. So charitable purpose, basically earlier it was section 2 clause 15, right? Now it's 223. In terms of the policy change wise, there is no change. Charitable purpose includes relief of poor, education, yoga which was added 2015 onwards, medical relief, preservation of environment, including watershed, forest and wildlife, preservation of monuments or places or objects of artistic or historic interest. The complex part is that advancement of any other object of general public utility. So when you compare 61 Act with 2025 Act, no change. There was a proviso in 61 Act in relation to GPU part, general public utility. There was a lot of litigation which was settled by Supreme Court in Ahmedabad Urban Development Society case 2022. So proviso says that in terms of the GPU part, if it involves in carrying on trade or business, so there's a criteria that you can't, there's a threshold that with the 20% limit. Meaning thereby that up to 20% you can do your business in terms of the GPO, because there was a lot of controversy whether this proviso of this 20% relating to the other parts or relating to the GPU, right? So now in the new act, this proviso has been deleted in the main section itself. So charitable purpose includes this A to G clause, which was there in the previous one. This proviso now has been merged with the main section itself in section 346, which relate to the GPU category. So when you compare your definition with GPU with 61 Act with 2025 Act, this is the change, but there's a no policy change. But in terms of the just to understand the concepts in an easier way, they have carved out that proviso and made that proviso into the main section itself. So that is a change basically, right? So in terms of policy change, the definition will remain same. Income part. So income. So now we are covering this charitable trust, non-profit organization. So income, I have covered only the one part, close to A. So it's income 224. Now it's part of 249. So income, so 61 says that income includes voluntarily contribution received by trust created wholly or partly for charitable or religious purposes, or by an institution established wholly or partly for such purposes, or by an association institution referred under clause 21. Clause 21 means the research association, or clause 23, which was the approval scheme, right? So they have mentioned clause 4, clause 5, clause 3AD, 3AE, clause 6, 6A of clause 23C of section 10. So whether there are any changes in the new act? The answer is no. They have just modified the language. Now what now now we are aware that the approval scheme under section 1023 has gone away from 1st October 2024. So now there is only registration scheme under this new act, under this income tax act 61, section 11, 12A, 12AA, 12AB, right? Section 1023C has gone away. So no approval has been given.
Sir, come near the mic. Your
Okay,
voice is very.
okay,
Come near the
okay,
mic, please.
okay, okay.
Thank you.
Now, okay, okay. So
Now it's
now,
okay.
okay. Thank you, sir. Thank you. So now this approval scheme has been gone away. So what changes has been brought out? Only and only section 11, 12, 12AA has been retained, right? So new definition, what is the new definition which says that? So voluntarily see, and under this income tax act 61, voluntarily contribution all means three type of voluntarily contribution. Section 10, section 12 says that of this income tax act 61, we says that voluntarily contribution will be deemed as part of income held under property under trust. This is the one thing. Second thing is that the corpus donation which you have received, right? Voluntarily contribution as a part of corpus donation it will be treated as voluntarily contribution. It will be treated as income. But section 11(1)(d), if you invest under section under 11(5), it will be, you will get an exemption. This is the point number 2 in terms of the income part. The third voluntarily contribution is anonymous donations, which will be taxed under section 115 BBC with 30% tax. So when you compare your income, what is a voluntarily contribution? Three type of voluntarily contribution they have mentioned now. But now in this new act, they have says that voluntarily contribution received by a registered non-profit organization. So the deeming provision, section 12, where earlier this 61 Act, it will be treated as a deemed under the deemed income. Now it's part of the main section itself. It's now says that any voluntarily contribution received by registered non-profit organization. This is a point number 1, right? This is a change. Deemed has been inculcated into the main section itself. So apart from that, there is no any change. Any association referred to in Schedule 3, table number 23. See now, so now in the new Income Tax Act, you will find that there will be a table and serial number they have mentioned. So serial number 23 relating to the research association. So earlier there was a clause 21 of section 10. Now it's part of Schedule 3, table number 23. Any university or other education institution referred to in Schedule 7, table number 19. So table number 19 relating to clause 3 AD and AE, wherein the total income is not exceeding by 5 crore rupees, right? So there was 3A, 3AB, 3AC, 3AE. AB and AE was relating to wholly financed by the government, right? AD and AE relating to the hospital and educational institution wherein the total income doesn't exceed 5 crore rupees, you will get the exemption. So it will be treated as an income, right? So the same thing has been mentioned, but the but major changes has been done. Clause 4, clause 5, clause 6, clause 6A has been done away because it has been discontinued from 1st October 2024 itself. So as for the definition part is concerned, there is a no change, right? There's a no changes. But in terms of the now, what you will feel the changes, the tabular format has been given in the section itself. In the schedules part, they have given in the section itself. So that is the only change. Apart from this, there's a no specific policy changes happen. So when we are talking about this registered non-profit organization, so I have given the name RNPO. So it's easy to understand. So registered non-profit organization means what? The section define itself. What is the meaning of the? They have changed the terminology, new terminology they have given in the section itself, in the chapter itself. So section C, this, as I have mentioned earlier, in the main part itself, in the main chapter itself, the interpretation clause has been mentioned. So section 355 in this, in the chapter 17 of this charitable, of this registered non-profit organization, they mention all the interpretations, right? What is the specified income? What is the registered non-profit organization? What is the meaning of relative? What is the meaning of accredited income? So section 355 has given the meaning of the interpretation. So registered non-profit organization means a person who is having a valid registration under any specified provision, right? So clause G says that under any specified provisions. So specified provisions they have defined under clause M. Specified provision could be under the erstwhile act, under the erstwhile act 61, under section 12A, 12AA, 12AB, or 23C, because the approval which was now has been discontinued from 1st October 2024, but you are having a approval regime until that got expired, it will continue, right? So if you're having a registration of 5 year under 1023C, it will be continue till it expires. After that, it will be transferred to the section 11 or under the new act regime. So registration means includes a provisional registration, because as and when you will apply the registration where the commencement of the activities has not commenced, the business has not commenced, firstly you will get the provisional registration. So provisional registration or registration under section under the erstwhile act or under the new act under section 354. So this is the meaning of the registered non-profit organization under the new act. So earlier the chapter name was charitable religious purpose. Now the terminology has got changed. See, uh, in the previous act, in the erstwhile act 61, when we terms about the registration part, all procedures are remain same. So we will not spend this time because this terminology has remained same. But I will highlight one thing that in erstwhile act 61, so section in the income part, section 224, clause 22I, which says that trust includes any other legal obligation, right? Whereas in section 13 itself it says that trust includes any other legal obligation. So now the question is, what is the meaning of the other legal obligations? So it means that it doesn't mean that only a trust who has been created can apply for this or can do this charitable activities. It could be your societies, it could be your company, section 8 companies, section 25 companies, or it could be any other societies. It could be an institution financed by the government. So earlier that was not defined. Now under section 332, when you apply for the registration, means who can apply for the registration, that is the main thing. So they have categorized or broadened the way in such a way that they have defined that who can apply for the registration in terms of the any other legal obligation. It could be, so section 3321 is the first section which relating to the registration, right? So now you keep in your mind the repeal and saving clause as well. Your registration is valid, like you have 10 years or 5 years or 3 years, whatever the period you are having till it, you will continue to govern. After that, the registration will continue to apply in as per the new act. If you are a new person or new entity want to get registered, the following person may, for claiming the benefit under this part as a registered non-profit organization, may make an application for registration in such form and manner. So they have defined like a public sector company, a society registered under the Societies Act 1860, Section 8 companies or Section 25 company or university established by law, an institution financed by the government. So they have defined in the schedule itself, serial number 27, 29, 36. uh, there is a clause called section 1046, which is doing the GPU category. So they can also either you can claim register under section 1046 or section 20, 11. So they have defined it. These type of persons can apply for registration if they want to take the benefit. Schedule 7, they have defined item number 10 to 19, wherein the major part is that university or hospital financed by the government, wholly financed by the government, or university or hospital where it is not it is exempt, where if the income is not exceeding by 5 crore of rupees. So they have defined each and everything that these type of persons can apply for registration if they want to benefit under as a non-profit or as a charity purpose or under this chapter. So as far as this registration is concerned, there is no major change. One change is that section 332 subsection 2. So I have given the previous section as well. So earlier the section 12AA, 12AB, right? And section 11.1, 11.1, clause A and clause B. This is the left side. See, when you apply for registration, right? So normally the concerned authority will check the genuineness and other things like whether you are fulfilling or not. Now, in section 11, we says that you will get an exemption only and only when you are registered and applied such income in India, right? Income in India for when you get the exemption. Now, they have categorized in a much broader way. they have said in the main section of the registration section itself, they specified that such person shall be eligible for the registration if such person is constituted or registered or incorporated in India for carrying out one or more charitable purposes as referred to in section 2 clause 23, or one or more public religious purposes, and the properties of such person are held for the benefit of general public under an irrevocable trust. So two type of trust, revocable or irrevocable. Revocable means you have a power to revoke, so that means it will be clubbed in the hands of the transfer itself. So for getting the benefit, it should be an irrevocable trust. So that's why section 11 says that subject to the provision of section 60 to 63 under this Income Tax Act. Now they have brought these changes into the main section of registration itself, wherein you need to prove that such person is constituted in India and the properties are held under trust for the benefit of the irrevocable trust and for the general public and wholly for charitable religious purposes in India and partly for charitable religious purpose in India if such person was constituted or registered under the prior to the Income Tax Act 61. So what changes that I have mentioned? So only this changes is that all sections 11, 12, AA, 12, AB, they have clubbed into one section 332. The one major change that earlier at the time of the exemption under section 11, the conditions are prescribed. Now at the time of the registration, the same as prescribed that at the time of the registration, you need to prove that he will check the scenario that whether the registration deed of your trust is incorporated in India for the general public purpose and the properties of such trust are held for the general public and under the irrevocable trust, whether it's a wholly charitable purpose or partly charitable. Partly will allowed only in cases when the trusts are created before 61 Act. So right, so this is the changes only at the time of the registration. So this tabular has been given at what point of time and what is the time period for getting the registration. So this is the basically a table which is a part of the section itself, right? So uh, uh, so 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 in this case, so I have plotted these income tax at 60 on the left side. The remaining sections are relating to the 2025 Act. So serial number A, serial number B, the table has been given under the C, the time limit for furnishing the application, at what point of time you need to furnish your application, time limit for passing the order by this concerned authority, and validity of registration. So I have plotted into the heading wise, where the activity is not commenced, the same thing, which was part of the earlier 61 Act. There is no major change. The firstly, you will get a registration for 3 years and it's a provisional registration. The subsection 8 itself mentioned in the section itself, section 332, it says that 3 tax years it will be valid where the activity is not commenced. Where the activities have commenced and you are applied for the fresh registration, it will be applicable for the 5 tax years. The time limit has been mentioned. Passing the order and time limit for furnishing the application has been mentioned under the under the serial number 2. Uh, Serial number 3, the so I have that's why I have given under the heading wise as well. So it's easy to understand which type of applicability will be applicable for the particular case. A provisional granted and equities have commenced. So earlier it was 3 years, now you will get 5 years. So a total, we can say that 80 years will get the registration get benefit. 3 years for the provisional part, and if the equities have commenced, so 5 tax years commencing from the tax year in which such application is made. So now if the provisional is due to expire but activities have not commenced, so item number 4 is there. So since it will be applicable for 5 tax year, but it will not for the commencing from the tax year. It will the next from the subsequent year in which the application is made. So that we need to keep in mind. Item number 5, where the registration is due to expire then close for 5 tax years flowing. So maximum period you will get in terms of the 5 tax years. Switching of this scheme under section 333, wherein you want to get an like section for 1046 or section 1046 say, or any other regime, you want to switch it over, you want to standard, and you will get to exemption in that sections. So and if you want, earlier you would covered under section 1046 and 1046A, now you want to cover under section 11 or under the new tax act, so it will be applicable for the 5 tax years. If you want to modify your objects, so the period has been mentioned and it will be applicable for the 5 tax years. So suppose your income for the last 2 years is doesn't exceed 5 crore rupees. So 5 crores, the 5 tax year will replaced by the 10 years. So same has been mentioned in the income tax act 61 as well. So there's no change. So in case of delay in filing, so delay can be condoned. So there is a writ jurisdiction before the High Court as well if the delay is not condoned. So you can knock the door of the High Court to get the justification of your case. Uh, if you are not filing your application within time, so exit tax, you will have to pay the accredited tax under section 115 TD of the old act now with the new act as the new sections which has been prescribed under this new act, right? So after the getting your application, the same thing, the PCIT or CIT will call and will call the documents or make inquiries. If he is so satisfied about the objects and genuine, the activity shall pass an order. If he is not satisfied, uh, he can cancel or reject the application after getting an opportunity of being heard. So basically the same thing is there. So whatever the verification that the concerned officer or the PCIT have to done, they will do in as per the new act as well. So there is no major changes. Switching over regime, yes, you can switch over, but only one time you can get either under section this charitable or under the specific sections. So switching over regime under section 1046. So they have given in the table like item number 27, 29, 36, 42. Uh, like in case of section 1046, 1046A, or section 1023, 1021. So either you can be assessed under this charitable part or under this particular section part. So once you have switching over, you have to surrender your registration, but this registration you will apply under this chapter and it will be valid for 5 tax years. So as the previous year has been replaced with the tax year. Now, so registration, there is no major change, right? So, but yes, in case of the income part, uh, as I said, income in the definition section 224, now under the Income Tax Act, the income definition section 249. But how you would assess, how would you tax your income? So there is a change that has brought out, but there's a no policy change. But in terms of the uh, we can say that in terms of the understanding the concepts, so it's a change basically. Earlier, section 11 was there, right? So now 23C has gone away. So 11 has been brought into section 3 under the section 334. The 334 says that they have classified the income into two parts basically under the new income tax act 2025. Specified regular income and specified income. So what is the regular income and specified income? They have defined it. The Income Tax Act 2061, which says that I'm reading section 6011 because it's a very crucial thing to understand. Uh, so 61 Act says that income derived from property. What is the meaning of property? They have not defined it. Income. So income has defined in section 224. It includes your voluntary contribution. It includes your investment income. It includes your deposit income. It includes any surplus activities as well. It includes your capital gain as well. Income includes capital gain as well. So income derived from property held under trust only for charitable or religious purposes, to the extent to which such income is applied to such purposes in India, and where such income is accumulated or set apart for application to such purpose in India, to the extent to which such income so accumulated or set apart is not in excess of 15% of the income from such property. Meaning thereby that this exemption is available up to the extent you applied your income, and if you want to accumulate it, it's allowed up to the maximum 15%. But they have not defined what is the meaning of the income. Income includes everything as per the section 220. 4. Now, they have defined in this way. They have defined the specified income, they have defined the regular income, just to clarify the concepts in a much more clarified way. So regular income means at the rate in force. Rate in force means at which rate it will get applied, right? Normal rate as a trust rate. So now income clause A says that section 335, income from charitable or religious activity for which a registered non-profit organization is carried out, right? This is the new thing. Earlier, it is deemed that any income is the charitable or religious activity which is carried out is part of income from property held under trust. Now they have defined in this way that income from charitable or religious activity for which this registered non-profit organization is carried out. This is the point number 1. Clause B, income other than income covered. Clause E. Clause E, we will cover it. Derived from any property, deposit or investment held only for charitable or religious purposes. Earlier, it is mentioned only that income derived from any property held wholly for charitable or religious purposes. Now, they are classified in such a way that deposit or investment income is also part of your income held, property held under trust. So is there any change? No, they have just clarified the way in such a way that investment and deposit income is also part of property held under trust. So that is a change basically. Clause number C, income other than clause E derived from any property, deposit or investment held in part for charitable or religious purposes. So this part for charitable or religious purposes was part of clause B of section 11.1, right? Which will be applicable wherein the trust was registered before that's at 61, right? So they have defined that deposit or investment income is also part of your property held under trust, part for charitable or religious purposes. This is the point number C. Voluntarily contribution received. Earlier, it is part of section 12. Section 12 says that it will be deemed, it was the deeming provision. Section 12. Section 12 says that it will be deemed as a voluntarily contribution, property held under trust. Now, there is no deeming provision. It is inculcated into the main section itself. Under section 335, it says that it's part of property held under trust, right? So this is the change. But policy change, there's no any policy change. Deeming provision has been carved out and it's part of the main section itself. Point number E, which is the main thing. Gain of any commercial activity permissible. See, there is a section called section 11.4 and 11.4a, right? So there's a lot of controversy on whether the charitable trust can do the business activity and the GPU category, general public utility category, can do the business activity. The answer was yes, but there's a lot of controversy. How can do their business? And if business is permissible, at what rate of tax it would get levied? Ultimately, it's part of your normal income because it's allowed. Section 4 and 4a. We will come into that. But how it would be get taxed? Now they have specified in a section itself gain of any commercial activity permissible. So earlier section 11.4 and 4a, now the section is 344 and 346. It is part of your regular income, right? So 5 categories they have mentioned now in the regular income. Income voluntarily contributions. See, clause A, income from any charitable or religious activity. Income other than income covered in clause E means commercial activity derived from property. So they have added deposit or investments. And in the clause C itself, where you are carrying your business as a part which is allowed if it's registered before 61 Act. Voluntarily contribution received now deemed has been come into the main section itself, and gain of any commercial activity permissible. So it's part of the regular income. So regular income means you will be assessed under the rate in force. So this is the point number 1. So how it get taxed? So section 11 says that up to 85% you can apply to your income, right? Applied is a much broader way than the expenditure. We are not going to that type of interpretation. So 85% you can spend it out. That is mentioned in the section 11.1 itself. So new section has been brought into picture. So they have made the section income is one section, application is another section, tax is another section, corpus donation is another section. Earlier it was part of main provisos and explanations. So now it's very easy thing to understand. So where you 85% or more of regular income, you will apply it. So you don't need to pay any tax. This is point number one. As per section 336. The same thing, section 11. Now it has been replaced with section 336. Just language change, but the theme is or the content is same. Either you can 85% if you are spending or applied less than 85%, you can accumulate as per section 11.2, right? Under the Erstwhile Act. So now this accumulation is permissible under section. So 11 subsection 2 has been replaced with section 342. So the same has been accumulated. So you don't need to pay any tax. So in any other case, if the 85% of the regular income is reduced by the application of income, if you 85% income, now you applied 60%, so you have to pay the 25% tax at the rating force, right? So taxable regular income. So section 11, earlier it was part of section 11.1. Now it is covered under section 336. So I hope I'm able to clarify the aspects. So if there are any questions so far. So there is a one. Yes,
So
yes.
can we interpret that now the commercial activity has been allowed in total without any restrictions or any
No,
preconditions?
no, sir. S- Under the GPO category, it is up to 20%. The same thing was there under the
Okay,
proviso. So same we will cover under section 344 to 346. The contents will remain same, but they have mentioned thing is that you need to keep maintain books of account separately. So
correct, correct. That's good.
one condition they have made out. We will come into picture.
Okay, thank you.
Specified income. Specified income earlier it was there under the respective different sections like 115 BBC, 115 BBI. One is the anonymous donation. So anonymous donation is part of your voluntarily contribution per se, right? It will be taxable. There is no doubt about it. So wherein you doesn't maintain your list, the record and identity of the donors. So it will be called the anonymous donation, but there's certain exceptions up to 1 lakh or 5% of total donations, whichever is higher, so it will be exempt. Otherwise, you need to pay tax at the rate of 30%. But wholly religious purposes was exempt in that section. So that section has been retained. So this specified income they have made under section 337, right? So 337 section, they have made the table and there are 13 items. So this is the point number one. If you're getting anonymous donation and if you have breached these conditions of these sections, you need to pay tax, right? So this is the one. So, but the old definitions and the contents are remain same. Point number two. See, any portion of income applied by directly or indirectly for the benefit of any related person. So related person they have defined under the erstwhile act as well as in the new act. So related person, the definition same. Now what they have made changes that computed in the manner as may be prescribed. Earlier they have mentioned section 3 to if you have lending any money, if you are giving a rent-free accommodation to a related house, it will be treated as uh, the benefit to the related person and you will pay the tax under the specified regime. Now they will made in the rules itself. They will not made in the section. So these are as may be prescribed. So the corresponding section was section 31C, section 13.2, section 13.3, and the specified income was mentioned under section 115 BBI explanation D. I have mentioned it, right? So in tax in the column C, it is mentioned that in which the in which year the tax, in which tax year it will be applicable. Any portion of income applied. So see, the one section was 115 BBC, another section was 115 BBI for the specified income. You need to pay tax at 30%. Item number C, so all sections. Item number 3, wherein you applied your income outside India. So earlier it was part of explanation E, now they have covered under the item number 3. Any investment or deposit made in contravention of the provision of section 350. 350 means 11.5. If you made contravention of section 11.5, you need to pay tax under the specified regime. Or right. So earlier there was section 13(1)(d) and 11.15. The specified income was mentioned under section 115 BBI clause C itself. So this is covered under item number 4. So this is item number 5, which is the blue, which I mentioned, isn't changes. So if you are a Gurudwara or trust and church, if you're getting a donation for repair or renovation in your church, so you are having an option to treat this donation as a corpus donation. So it will be treated as a deemed corporate donations. If you violated it, it will be treated as income. So earlier in the Income Tax Act 61, it is that explanation 3A and 3B of section 11.1, which is mentioned in the left side. So item 5 says that it will be treated as a deemed specified income. Earlier, there was no any provisions. So earlier it was saying that it will be treated as income. There was no anything mentioned under section 115 BBI, but under this new act, this deemed corporate donation will be treated as, if you violate any of the conditions, it will be treated as specified income and you need to pay tax at the rate of 30%. So that is a change which has been brought out. Item number 6. So item number 6, so if you have accumulated your income, so there are the 4 conditions, 4 parameters. If you have not applied, so same as there under section 115 BBI, explanation B, C, D. So this is item number 6. Any portion of accumulated income, it was applied to purpose other than the charitable purpose, which is accumulated under section 11.2, right? This is point number 1. Point number 2, any portion of accumulated income, if it ceases to be accumulated, if you have not invested under section 11.5, corresponding to section 350, any portion of accumulated income, if it is not applied as per provision for which is accumulated set part within the period. See, or 9, any portion of accumulated income which is correct or paid to any other registered non-profit. This is a specified income you need to pay any tax. So item number 6, 7, 8, 9 relating to your accumulated income, which is corresponding to section 11.2, wherein the 11.3 has mentioned that if you have accumulated your income, you can't do this thing. You have to prescribe, you have to follow these conditions. You have to invest. You can't make your contribution to any other party, which will not be treated as an application of income. If you violate it, it will be taxed under section 115 BBI under the old act. The same thing has been brought into the new act as well, so there is no change. Item number 10 and 11. So this changes. This is a new thing as per my opinion. See, any income applied to purpose other than charitable or religious purposes for which it is registered, right? If I'm applying any income, earlier there is no any clause under 115 BBI because there was a condition of specified violation, the PCIT can cancel your registration, right? But here it is mentioned that apart from the cancellation, you need to pay tax under the specified income as well. So this item 310 is a new thing. So any income applied to purpose other than charitable religious purposes which is registered. The same is not there under section 115 BBI. So that's why I highlighted in the blue. Item number 11. So there's a two section 11.4 and 11.4A. 11.4 says that property held under trust includes business undertaking. So what is a business undertaking? We will cover in the next subsequent slides. But if you claim that it is held for charitable purpose and it will not get included in your income, the AO has power to determine whether you are showing this income as correct or not. So any income determined by AO under section 11.4, which is corresponding to section 344 in the new act. Such such income, excess income, we can say that it will be treated as a specified income. You need to pay tax at 30%, but this condition was not there in the new act. So this item 11 as well is a new thing which has been there in the new act as far as this specified income is concerned. Item 12. If because there is a section called 11.5, you need to make investment as per the prescribed mode, which has been prescribed in the section itself. If you are having an investment and you have not converted your assets within the prescribed period into that regime 11.5, and this 11.5 has now been given in the schedule 16, right? 16. So 11.5 has now been carved out in the section, and section 350 has been the whatever the investment is there, the same has been mentioned in the schedule, that they have brought out the schedule for this investment. So you need to pay tax on the fair market value of the assets after expiry of the prescribed period. So this is also a change because the fair market value has not prescribed in the new act. But earlier there was that you need to pay tax, but the fair market value is a new thing. See, now any deemed application, two type of application. One is application 85%. Another is that if you have not received your income, so when you are not received your income, you will not able to apply, right? So when you are under the accrual part, you are not getting an income, but it will be treated as deemed application income. So as and when you will receive your income, you will apply for in the subsequent year. So as per this explanation 1 and 1B, section 11.1. So if you violate that condition, if you not applied, so 115 BBI will get apply and you need to pay the specified income at the rate of 30%. The same thing has been brought out in the new act as well. There is no any change. So two things which is not there in the income tax act, because it's a new journey from all of us to getting in the vibration of the new act. So there was a two clause called section 13.1A and 13.1B, which was there for the forfeiture section, wherein if you are getting an exemption, if you are violating the conditions, the exemption will get forfeited. So any income applied for private religious purposes or income created for benefit of particular religious community, what would happen in the new act? The same thing has not been mentioned. But under the specified violations, the cancellation benefit is there. The PCID can cancel the registration. But what about the exemption if you are getting, if the same can be revoked or forfeited, the same thing has not been mentioned. So I have brought out as and when the debates will get happen in the new act, so the same will get come into picture. So this is my initial view, that the same thing has not been there. So might be that there would be an drafting error or something like that, the policy change, but the government says that there's a no policy change. So what would happen? So I think in the budget itself we will see what scenario would get happen. So this is all about the specified income. So specified income, there are the 13 items you need to pay tax 30%. So earlier, in section 11, called 11.1C and 11.1D. 11.1C says that if you are up, so there's a section called section 338, which says that income not to be included in the regular income, right? So which is the corresponding section is 11.1C and 11.1D. 11.1C says that if you applied your income outside India, if you have created your trust for 52 or specified by the board, so any income applied means income you have applied, that type of income will not get included. This is point number 1, which is corresponding to section 11.1C, no change. 11.1D. So in the definition part says that the voluntary contribution includes the corpus, right? Corpus donations, it will get included. But you will get exemption under section 11(1)(d) as and when you invest under section 11(5), right? 11(5). So that means voluntarily corpus donation is your income. If you're not investing under section 11(5), if you are investing under section 11(5), you will get the exemption. The same thing is there in the new act. Corpus donation, there's a new section called section 339, which says that corporate donation will not be included in your income provided that you have invested under section 350, which is corresponding to section 11(5). This is the same thing. So if you applied your income outside India, corpus donation, it will not get included, provided. But corpus donation is your income under section 224 under the erstwhile act and section 249 under the new act. As and when you will get the exemption investment, the same you will get the exemption under section 339. So there's a no any policy change. Deemed, so new section, there's no new section, new heading that they have brought out. Deemed corpus donations. Explanation 3A of the erstwhile act. If you are receiving, if you are where the property of this registered non-profit organization includes any temple, mosque, gurdwara, church, or any other place, or any sum received for renovation or repair of such place made the option be deemed as forming part of the corpus, provided certain condition or need to prescribe, maintain corpus separately, apply such corpus only for that purpose. You need to make an investment under section 350, which is corresponding to section 11(5). It doesn't apply such corpus for making donation to any other party, any other third party. So violation will attract specified income. So this is a new thing that they have brought out in the specified income table, item number 5, which I have already highlighted that in the blue color. Earlier, it was treated as an income. Now, if there is any violation of this, it will be treated as a specified income. So, explanation 3A of the erstwhile act has been inculcated into section 340, but there is a no policy change. But yes, in case of the change in the violations, it will be treated as a specified income and will be charged at the rate of 30%, which is a new thing, which has been highlighted in the blue color in the previous slides. Application of income. See, section 11. See, section 11 itself says that income derived from property held under trust wholly for charitable religious purposes to the extent to which such income is applied to such purposes in India. Now, what is the language? The language says that any sum other than clause B, the income has been replaced with any sum. This is the first thing. Applied by it for charitable or religious purposes in India for which it is registered, which I have highlighted in the blue. See, I have a charitable trust. Charitable trust includes 6 things: relief to poor, preservation of environment, blah, blah, blah. There's 6, 7 things. I have applied the income, suppose for the education. I have registered as a charitable trust for relief of poor, right? But I have applied for the income for the environment of the preservation. So as per my opinion, under the old act and as per the previous judgment, if you applied your income for charitable purposes in India, it will be treated as applied your income, right? Now, under the new act, which it states that any income applied by it for charitable or religious purpose in India for which it is registered, if I'm registered as a relief of poor or medical relief, if I'm applying income from education, so it seems that I'm not getting any exemption for the income I have applied for the education because I have been registered as a relief of poor. but now I am applying its income for the education. So it seems that there will be a change, policy change in terms of the, I think litigation would be there because in the law, each and every word would get trigger. So that's why I've highlighted into the blue color part that there would be a change. I need to apply it for which it is registered earlier for the charitable purpose. Charitable includes as per the definition which has been given. So this is the thing that seems that there is any change. The second thing is that application of income, if you giving a donation to any other trust, so 85% of the sum given by donation made to other uh, charitable and registered non-profit organization, it will be treated as application of income. The third thing is that the two things, if in the corpus, it will not be treated as an application of income, but as and when you are invested or deposited back in the as per the scheme 11.5 or as per section 350 maintained for such purpose, it will treat it as application income provided that the investment has been made within the 5 years. So the same thing which was given under the explanation 4, the same has been brought in with section 341. So any amount repaid during the tax year towards any loan or borrowing, so from the loan on any amount prepaid, provided that the loan and such repayment is made within the 5 years. So the same thing, explanation 4, clause 2, the same thing has been brought out in in the clause B as per section 341. So there is no any change. But the following shall not be allowed as application of income. So earlier it was section 11.6. There was a various subsections, the same has been brought out into the main section itself. If you have claimed any deduction of your capital expenditure, the depreciation can't be allowed. The same thing, earlier it was 11.6. Now it's part of subsection 3 itself. This is the first thing. So any claim or set of deduction or allowance of an excess application of any preceding years, if you have, so earlier there was, so this has been brought out in 22 or 23. Earlier there was a litigation that if you are having a losses excess applications, whether these losses will be allowed or not. So from 23 itself, they have made the changes that any previous excess application you will not get allowed to get set off in the next year. So this is the same thing that has been maintained in the new act as well. So any sum paid as a corpus donation, if I'm making a donation as a corpus to some other society, it will not be treated as an application of income. Earlier it was part of explanation 2. Now it's part of clause C itself. So this is the new thing, but it's not a new thing. They have made a specifically that any application from corpus, loan or borrowing, accumulated income, specified income, or deemed accumulated income shall not be considered as application for 11 for 102. So they have specified that because the loan and borrowing, the repayment will be treated as application. So anything from the loan and borrowing will not be treated as an application of income. So deemed application, earlier it was part of explanation 4, wherein you are not getting any income and you are not applied your income because there's a shortfall that you have not received your income. So the same thing has been maintained under this subsection 5 itself. It will be treated as a deemed application of income and it will be covered under subsection 1 itself. That right. So there's a one change. Earlier this uh, uh, yes, earlier this deemed application, you need to file at least 2 months prior to the due date of filing your return. The same thing has been changed with the word on or before filing of return of income under section 263, which is corresponding to section 139. So 2 months now has been replaced with on or before the due date of filing the return of income. Right, this is the change that has been there in the new act. Capital gain, the same thing is there. So if you have gain income in your capital gain, if you're investing in the new capital assets, it will be the whole of the net consideration. It will be uh, treated as an applied for your income. So it shall be deemed as application of income. So there was a lot of controversy that capital gain can you applied for the charitable purpose as well, because there was section 11(1)(a). Now it is mandatory the language that the income from capital gain shall be deemed as application of income if you are going to invest under the capital gain. So earlier there was a controversy that capital gain can be applied for the 11(1) itself, means by charitable purpose rather than investing into the capital gain. So now they are making a mandatory that it will be treated as application income, means capital gain you have to invest in the capital assets itself. Accumulation income, which is corresponding to section 11(2). So there's a one major change which is says that earlier you need to file your statement at least before the 2 months prior to the due date. Now it is before the due date. The same thing has been mentioned. So any accumulation credited or paid by to another registered non-profit organization, it will not be treated as application of income. You need to make investment under section 11(5), which is corresponding to section 350 of the Act, right? So if you want to change your purpose, you can apply, which is corresponding to section 3A. So this is a new thing, but this is the last thing that I want to highlight within the 2 minutes. 343, it is a deemed accumulation income. See, 15% is allowed, no doubt about it. But there was a thing that if it's 15% is allowed, there was a lot of controversy that whether this 15% you need to maintain your within the prescribed mode of 11(5) or any other mode. Now they are mandatory that 11(5) will section 350, which is corresponding to 11(5), it is mandatory shall be invested in any of the modes permitted. So this is a change that they have brought out, because 50% accumulation is allowed, but there was a lot of controversy. Some judgment says that no, it's not mandatory. Some judgment says that it's mandatory. Now 11(5), if 15% you are going to accumulate it, now you have to maintain as per section 350. So I think we are running short of time, and because each and every aspects will take a lot of time. So I think I have given a lot of flavor as per the new act. Just last thing I want to highlight is that there's a changes which has been happened uh, regarding the status of the charitable institution, which has been changed. See, section 164 subsection 2, which says that the charitable trust will be assessed as per association of persons, right? So same clause is not there in the ITA 2025. Now the question is, if it is not there in the 2025 Act, it will be treated as an AOP, or it will be treated as something other thing like individual. So, or the judicially be defined, or the precedent which has been set as per the old Act 61 will continue to apply, that we need to see. So all these facts, so I am concluding my presentation. So if there's any questions, so please let me know. So I hope I am able to deliver or I am able to communicate in effective way so that the new act will uh, uh, easy to understand. So is there any questions?
No, sir. Thank you.
Okay.
Sir, can we get a copy of this presentation?
Yes, sir.
PDF copy?
Sure. Yes, sir.
Thank you, sir.
Thanks a lot.
So can we close the presentation?
हाँ जी सर.
So there's a one question: can a trust accumulate the unspent for 5 years and spend it for remaining expenditure? There is some question as per the chat box. Will the session and the presentation be shared? Yes, I will share it to the organizers. Does section 346 to 344 to 346 mean that an NPO can penis even if it is not directly connected to the main charitable activity? No, it should be connected to it should be incidental to the main business of your charitable activity. It doesn't mean that you can carry your business activity. The word is incidental to the main charitable activity. Okay. The recording of presentation will be shared till Monday morning, so please share PPT will be shared with recording link. Can a trust accumulate the unspent amount of 5 years and spend it for one expenditure which is partial? See, if you accumulated your money as per section 11(2), if the purpose is mentioned for revenue expenditure, it will be revenue expenditure only. If it's a capital expenditure, it will be capital expenditure only. If you want to change your nature under section 11(3)(a), you go to the ITO and says that I want to change the purpose. He will allow it on. After that, you can change your purpose, right? Does 346 mean that? So I think I have given all the queries of your questions. So thank you very much.
We conclude today's webinar. Sincere thanks to our organizers, CA Dr. Raj Chawla sir, and our esteemed speaker, Advocate CA Anil Chachra sir, for this valuable insight. We also thanks our all participants for joining us. Have a great day ahead. Thank you so much, sir.
Thank you. Thank you.